When you have a music business question that you can't figure out, do what all the stars do. Ask Orville. Here is the star of the show, Orville Allman.
I'm Orville. I'm with the law firm of Allman Law PLLC. We have a question from a viewer today. What rights does the artist have in a deal, and what rights do the label have? Well, it all depends upon which label and which contract. No two labels have the same contract. They're all different, but there are certain things that are in both contracts. Let's look at the artist first. Things that you're going to find in almost every artist contract. You're going to find out how much the artist is going to get paid when they record or when they sign the contract. These are called advances. They're recoupable against the royalties, which means they can take the advances, the amount of the advances back from the earned royalties. You normally get these when you sign a contract. You normally get these every time you make the sound recordings that's required under the contract. You'll have provisions for accountings on how you'll get paid, so you show what expenses were spent on you, what marketing costs are recoupable against you, what promotion costs are recoupable against you, how much they spent on the videos that they're going to recoup against you. Another provision that will be in the recording agreement will be provisions for accounting that will show how many times a year that you'll be accounted to by the label. It will show what expenses that they've charged against your account that they're going to take away from your earned royalties. It will show what royalties you've earned on the sale of your recorded product, downloads, physical product, ringtones, any type of sale or exploitation that the record company got paid for that has under your contract that you're supposed to get paid for. They will have that listed in the contract. They'll normally have obligations for release of your product, that if they don't release it in such a period of time, you'll have certain objection rights, and that if they don't release the product, that you will have termination rights where you can get out of the contract. You'll also have certain approval rights of what they can do with your sound recordings without your permission. Classic example is, can they put them in an X-rated movie or a porno film, or use them for certain commercials such as political campaigns, and would look like you're endorsing a candidate or endorsing a certain product or something like that without your consent. These things are going to be in there. There may be certain exceptions to exclusivity where you could be a side musician on another person's project. They'll have certain restrictions on how you can do that, such as like your image couldn't be used, your group name or your professional name other than as a musician credit couldn't be used. They couldn't use your name to try to sell their records or feature you where you could be a featured artist, although there are things, if you go back to the label and get permission to do that, if you had a certain project by that, but the contract's normally going to prevent you from doing that unless you have the permission from the label. So these are the type of things that the artist contract will have, mostly that their product's going to get released, how much product that they'll get to record, how much money they're going to make as far as advances, how their royalties are going to be calculated, how much royalties they're going to make. These are the type of things and the rights that the artist will have. Now, from the record company's rights, what they're going to be basically looking at is they're going to own almost everything you do, as far as they're going to own the artwork, they're going to own, normally they own the website that you're going to work on during the term of the contract, or so for so long after the term of the contract, giving them enough time at least to exploit the last record that you put in. And even after that, once they're no longer the exclusive owner of that website, they'll still have the right to have a website to exploit your product on that they had, that they recorded while you were on their label. They will own the masters, the sound recordings that you recorded during the term of the contract. They'll have 100% ownership of those. They'll have exclusivity rights to your services as a recording artist, so anything you record during the term, they will own that. They'll own the copyright in that. That will be in the contract. They'll have the right to use your name to exploit those recordings. You'll also have, their licensees will have those rights to use your name. Normally you can get approval of the photographs and the artwork that they use to exploit those records. If you don't ask for it, you're not going to get it.
The material is for informational purposes only and does not in any way constitute legal advice or create an attorney-client relationship. The information contained in this website cannot and is not meant to replace the advice of competent legal counsel licensed in your state. To get your question answered, send an email to john@NashvilleNinjaMGT.com with questions for Orville, and visit the Ask Orville page on Facebook and leave your question on the wall.